Additional Sessions Judge Sanjay Jindal has categorized certain issues. One, the issue of the forcible abduction, putting into a PAC truck, taking them to two different spots, their brutal killings and throwing them into the canal, based on the statements of 5 surviving eyewitnesses: Zulfikar Nasir, Mohammad Naeem, Mohammad Usman, Mujibur Rahman and Babudi. These 5 men were PWs 1, 2, 3, 4 and 11 in the trial. They have very, very bravely come to court and testified as to how the incident took place, how they were picked up. They were young boys of 16 or 17 at that time. How they were pushed into this vehicle in the middle of the night, how they were shot and then thrown into the river, how they escaped because the men who were shooting them believed that they were dead. When you read the testimony of these 5 victims, you get shivers up your spine. As a practicing lawyer who has practiced in courts for 28 years and criminal law is my forte, when I reread their evidence at the time of final arguments, I was again horrified. So what is being said here is that these stories must never be forgotten is absolutely right. Because when you read their testimony, you realize what the state has done to these innocent men and how they were treated. The judge has accepted their testimony in totality and has said that there is no doubt about the fact that the incident of abduction and brutal killing by men in uniform stands established. However, a prosecution must go further. When you prosecute 16 people for murder, it is the duty of investigating agencies and it is the duty of prosecuting agencies to provide corroborative material to establish that these men in the dock were actually the men who committed the crime. Whose responsibility was it to provide that corroborative material? It was the responsibility of the prosecuting agency and the investigating agency, the UP police, of whom Mr. Rai was a member at that time. I know that investigation was subsequently transferred from them within a very short period of time. But I also know from experience that the initial investigation, the initial seizures you make, the initial evidence you seize is the most critical evidence in a criminal trial. This is where the judge has said that the prosecution has miserably failed. Because although he believes the testimony of the 5 surviving eyewitnesses, those 5 men said, we cannot identify anybody. It was the middle of the night. These men were in uniform. They had helmets on their faces. We were asked to bend down. We were in fear. And we've never seen them before. We cannot identify. The first failure of the investigating agency, and I don't know how these 19 men were picked up eventually. There must have been some reason why these 19 men were picked up. One would have imagined that the very first protocol of investigation is that you put the survivors through a test identification parade. It was not done. Whose fault was it? The UP police. It was possible that back in the day, in May 1987, they may have remembered somebody. But by the time they were able to testify in court, it was 2006 to 2009. It is humanly impossible for any one of us to remember or identify people we've never seen in our lives before, 20 years after the occurrence. But I'm asking myself a question as an officer of the court. What is a judge supposed to do with this evidence? Ultimately, he has to acquit or convict. And if he convicts people for 302, he must have evidence to back him. Where was that evidence? And why was it missing? Now, Mr. Rai has spoken today, as well as in other forums, of the larger conspiracy. Who said that in court? Did anyone say that in court? It's a simple thing. It's not rocket science. 42 odd men put into a truck. The men don't know the name, the number of the truck that was URU 1498. But they were people who went to, who saw a particular truck being washed. Someone should have said that this truck number was URU whatever. There was no one who said that. Now I am asking myself this question. Who are we blaming? Because one of the paramount and most important element of a criminal trial is investigation. So there was suppression of evidence. We all know when police officers investigate police officers, evidence will be suppressed. It's not a knowledge we've gained after Hashimpura. We know it all the time. Police officers investigating police officers will by and large suppress evidence. There is also the question of diligent investigation. So apart from the suppression, basic protocols of investigation were not carried out, and I'm making that statement with a sense of responsibility, having been frustrated through this trial, looking at the evidence that the prosecution brought. No seizure of the truck, no seizure of the bloody water. What do you expect the court to do? How does he connect these 19 men? Firstly to the battalion in question, and then to the truck in question. And he's saying that this horrific incident has taken place. There was indiscriminate firing that took place inside the truck as well. There must be some evidence. You allowed the truck to go. You allowed the weapons to be reused by the PAC. You allowed the weapons to remain with the PAC. By the time it was seized and sent to the CFSL said, hello, what are we supposed to say from this? It's been used subsequently. How on earth can a prosecution succeed if this is the quality of evidence? And there is culpable failure of the state, successive governments who rule Uttar Pradesh and the centre, and I would say officers in uniform, whoever they were. People responsible for investigating this crime did not do so. Whether it was through negligence, whether it was through incompetence, or whether it was through deliberate suppression of material, it has not happened. There is no point recounting conspiracy theories after the incident. Many of these people came to court. Many of these people testified. What is the nature of their testimony? The investigation was transferred from our hands after 30 odd hours. Oh, we didn't seize the vehicle, we didn't seize the bloody water, we don't even name the truck in question. How do you build on that? So as someone who appeared for these victims through a long and lonely struggle, that's the other point I want to make. Once something like this happens, 28 years after the incident, suddenly the whole civil society wakes up. Suddenly you have television programs, and I've just been wondering why I've been giving so many interviews at late. Through this lonely struggle of 28 years, it was only the people of the men and women of Hashimpura who kept the flag flying. There was no one with them. They were poor and desperate in 87, they are poor and desperate today. And I think we must recognize that. There is no point in making a big civil liberties collaboration at the end of a struggle when you don't walk with them through the struggle. And we haven't done that. We haven't done that, and I say that with respect to the media, I say that with respect to members of the force, I say that with respect to ordinary members of civil society. These were an abandoned set of people from Hashimpura. We abandoned them in 87, we abandoned them later, and today we are shedding crocodile tears. And it will not work that way. No incident of this kind should ever go unpunished. But for it to go punished, we must be vigilant as a community. Lawyers, police officers, politicians, ordinary students and teachers, all of us are invested in it because this is our future. If the men and women of Hashimpura are crying today, it's a shame on us. It reflects on how poorly our system functions. And as a member of that system, I am more than happy to take responsibility for what is happening. There's been much talk about the way forward. What is the way forward? Now, Vrinda and I were very, very clear, and we actually knew this would happen. Because what do you do with evidence as bad as this? So the question arises, so we move to the High Court, ask for an appeal. What is the magical thing that will happen? I have a response to that. Justice means different things to different people. Justice, sometimes and always in fact, is that the perpetrators must be punished. But if that has not happened, can we not expand the concept of justice? Cannot a superior court look at this evidence and say, all these people could have collected all these pieces of evidence on these days and they did not do it, and today fix accountability on them? Because unless you punish people in power, this will happen again and again and again. Cannot a superior court look at the horror and expose the horror of the incident to the world? And to that extent, this judgment is very, very disappointing. Because what this judge has done is, he's looked at it very clinically. जैसे कि भाई हमारे बाहर पे नुक्कड़ में एक छोटा सा इंसिडेंट हो गया, जामिया के बाहर में 2 लोग थप्पड़ मार दिया, इस टाइप का इंसिडेंट. He didn't give it the importance an incident of this nature deserved. There was no mention of the wide-scale ramifications of an incident like this. And therefore it was a disappointing judgment from that point of view. And while he kept on saying about proof beyond reasonable doubt, which is the correct interpretation of criminal law, I would also like to ask him a parallel question. I'd like to ask that question to the judiciary at large. ऐसे cases में आप proof beyond reasonable doubt, custodial incidents में आप पूछते हैं, जब proof beyond reasonable doubt तो कभी मिलेगा ही नहीं आपको. पुलिस वाला किसी पुलिस वाले के खिलाफ एविडेंस नहीं लाएगा. तो पर आप इंसिस्ट करते हैं कि proof beyond reasonable doubt होनी चाहिए. I represent many accused persons in trial in terror cases. आपके यहाँ पे बाटला हाउस की ट्रेजेडी हुई थी 2005 में, जो बॉम्ब ब्लास्ट हुआ था in Sarojini Nagar, where 5 Kashmiri men are in custody for 11 years on zero evidence. मैं वहाँ पे आप कॉम्प्रोमाइज कर लेते हैं, कोई प्रूफ नहीं है, पर आप बेनिफिट ऑफ द डाउट प्रोसिक्यूशन को देते हैं. बेनिफिट ऑफ द डाउट यहाँ पे आप अक्यूज को दोगे, उधर आप प्रोसिक्यूशन को दोगे. दोनों तरफ जो विक्टिम्स हैं वो मुसलमान होंगे, as an accused or as a victim. So you shift the standards according to what is suitable. In a case like this, you insist on proof beyond reasonable doubt. I'm asking, why don't you insist on proof beyond reasonable doubt when innocent men are put in custody under the UAPA Act, under Makoka, under Pota, and now that horrendous act which has come out of Gujarat? There, you cover for the prosecution. You say there's no need for proof. Kiya hoga hai log. So what is this system that we are defending, where basic elements of the law are not upheld? What I really want to say is that 2 things. One, we must never erase these things from our memory. Hashimpura must become a rallying point, not just for those men and women there, but for all other cases where civil liberty is violated. And we must always remember that it's not good enough to wake up 28 years later. It is important for us to walk the journey with victims of such crime. If we don't do that, this will happen again and again.